Again, I'm Linda Long-Bellil, Assistant Professor at UMass Chan Medical School, and I just want to welcome you. Um, Today, we'll talk about advocacy strategies for defending the rights of disabled parents in child welfare cases. There will be closed captioning at the bottom of your screen, and if you need sign language interpretation, you can find it under the More tab. Click on that, and several options will show up, um, and you can choose interpretation from there. We do have two sign language interpreters with us today, and thank you very much, both of you, for being here. So, today we're going to talk about working with parents, the fundamental principles, working with the other side, and filing a complaint. So, I'm going to turn this over now to Attorney Parthiban.
Hi, this is Kavya speaking. We briefly touched on this in our last training session, but ableism is quite baked into the dependency system. We know that parents with disabilities are disproportionately represented in the foster care system. Even though only 1 in 10 children in the US have a parent with a disability, they make up 2 times that amount in the foster care population. We also know that our history of eugenics and ableism has been baked into our understanding that the presence of certain divergent behaviors or diagnoses make people automatically believe that that person cannot raise a child. And so as a result, you have parents with stigmatized disabilities, mainly those with psychiatric disabilities or developmental disabilities, being assumed to be inherently incapable of caring for their kids. We even have some studies showing that within the first year of a child being born to some of those stigmatized disabilities, there's a removal. What that means is there's not even an opportunity for that parent to learn and show that they can be capable. People assume you're unfit and then remove. And the removal rates are as high as 80%. Now, we also have more recent high quality studies that have come out that show that disability is not predictive of abuse or neglect. Those are coming from more disability based understanding. Yet, the reality is that in court processes, dependency systems kind of reestablish this bias that parents with disabilities can't parent because they don't offer parents tailored accommodations or services. And so parents aren't able to progress in the reunification plan and might have their rights terminated. Next slide, please. And that kind of relates to capacity. So, capacity is oftentimes a loaded word for people with disabilities. We know folks with intellectual disabilities are often told that they have low capacity because of an IQ score. But in fact, capacity is able to change. It's a spectrum. It's not a yes or no question. And that's true for disabled individuals and non disabled individuals. So, for parents with disabilities, their capacity to parent can grow even if initially we have some concerns. I also want to remind folks that the capacity for representation does not require a client to fully understand all the nuances of litigation. Next slide. So, some people might look at that disproportionate numbers of people with disabilities in the child welfare system and also the outcomes and say, okay, maybe there's a bit of ableism, but also maybe parents with disabilities can't do it. But what I want to remind people is that we need to step aside from individualizing social issues and instead maybe think about having a systemic analysis for why parents with disabilities are overrepresented in the dependency court system. This is an image by T.L. Lewis that kind of talks about how poverty, trauma, and disability feed into one another. So, if you think about it, many folks with disabilities live in poverty, often because there aren't accessible jobs for them or because state benefits don't provide you enough. And we know poverty is a huge indication for neglect and for other issues that come up, like heightened chances of domestic violence or housing insecurity that cause CPS to come in. We also know that poverty leads to trauma, and trauma can exacerbate disability. And then disability then feeds into poverty. And so it's this cycle that is not related to an individual's personal impairments. Next slide, please. So we're going to talk about briefly how you can work with parents with disabilities. And this is a cute little cartoon that kind of simplifies what we mean when we say accommodations. Accommodations is just a fancy word that means how do we change things so that everyone can participate and enjoy that benefit. So in that cartoon here, you see a porcupine wanting a balloon as well. But when you look at it at first, you think it's impossible to give that person a balloon hat. But then there's creative ways to let that porcupine still participate, like tying the balloon above the head. Next slide, please. And we need to be thinking about accommodations when we're working with disabled parents at various stages of the dependency process. And we want to identify which accommodation works best for them. Next slide. Something often that my organization talks about is readily accessible lawyering. And this is a practice that we encourage all attorneys to do. Accessibility is different from accommodations, even though sometimes those words are used interchangeably. Accessibility is thinking proactively. It's knowing that the world that we live in is one that is ableist and doesn't accommodate people with disabilities. And so it's thinking through like what are ways that we can improve our lawyering practices ahead of time so that more people can be able to engage in the same benefit. Accommodations are more reactive. It's more individualized. It's asking, what does this specific person need? So here are some default practices that you can all use to make your lawyering practices more accessible. Many of them, I'm sure you folks have already been doing, such as, engaging with humility, curiosity, and attentiveness. But there's other tools like plain language, which is avoiding legalese that we'll go into more. And then looking into what accommodations are available for certain disabilities that might come by more often. Linda, in the last training, pointed folks to the JAN, the Job Accommodation Network, which is this wonderful site where you can look up certain disabilities and what are some common accommodations for those disabilities. So if you've noticed that there's certain disabilities that are coming across you in your practice, you can look at JAN and proactively think about what you can provide those parents. What's the most important thing, though, is that you are prepared to ask the individual person what works best for them. And we're going to talk about that briefly next. Next slide, please. So one of the challenges when we're working in the dependency court system is that we all know that disability is often used against parents, and parents are aware of that too. They're aware that CPS is predisposed to viewing them as unfit if they have a disability marker, and that courts are going to kind of judge them. They also might be worried about the general stigma of that disability label following them, or if they do have a diagnosis that's more stigmatized and requires medication, that putting that label out there is going to result in the courts and CPS requiring them to follow a certain type of treatment. So all of these are very valid concerns. And when you're talking to your clients with disabilities or people that you think might have disabilities, you want to ensure that when you're telling them the reason that you're inquiring about their disability status isn't to kind of force a certain treatment on them, or that you acknowledge that there's that bias there, and say instead that this information is for you to ensure that you have more effective representation of those clients and that you can ensure that the case plan is one that really meets their needs. Next slide. So how do you talk to people about disabilities? Sometimes people worry that asking people about their disability status is something that's kind of uncomfortable or something you have to be apologetic about. So oftentimes I hear people say things like, I'm really sorry to ask, but would you mind? Is it okay if you can tell me if you've ever been diagnosed with a mental health condition? When in reality, people with disabilities are oftentimes aware of their diagnosis, have had that diagnosis put on them, and can talk comfortably about it. And it's more respectful to be direct. Disability is not something that's horrible or something we should be ashamed of or is going to trigger someone. So you can ask directly instead, do you have any mental illnesses or conditions such as post-traumatic stress disorder, depression, bipolar disorder, or if not, have you ever been misdiagnosed with those conditions? Next slide, please. You also want to ask about disability accommodations in a simple and non-judgmental way. If you remember that cartoon that we were talking about, oftentimes people hear the word accommodation and they think it's something really complicated So they might say no, that they don't need an accommodation, when really what we're asking our clients is there something that we can adjust, even if it's free or quick, that will make this process easier for you? So some things you can say is, is there anything I can do to help communicate clearly or help you access this meeting fully? Sometimes people have difficulties keeping track of dates and times for meetings. Is there something that I can do to help you remember to show up to your visitation, to show up to your meeting, like a text reminder or having a service provider work with you on that? You can ask them, sometimes people like following along with notes or captions. Do you want me to use that while we're meeting together so that you fully understand what's happening? Um, and then most importantly, you need to listen to what that person says. They usually know what's best. Um, if they say, I'm not sure, then you kind of want to start brainstorming with them about what options are there so that they can fully understand. Next slide, please. So this is a question we get often. What if your client disagrees with the disability label, which is common? We know, some certain labels are stigmatized and certain populations are over diagnosed with certain stigmatized disabilities. So totally fine. We acknowledge that. There's also some disabilities where maybe that person can't um, recognize that they have that certain type of disability. So what you do in those instances is you ask the client, okay, is there a more accurate representation of what you're experiencing? Maybe you don't have schizophrenia, but can you describe to me, you know, how your experience of your mental health is? You also want to remind the client that even though sometimes disability labels are pushed on them, in court reports and court decisions, even if we don't acknowledge the disability label, disability is often the elephant in the courtroom and is used against them. So you can even point to their court reports like, look, here, CPS is saying that you are often very angry or that you don't understand what's being asked of you. And these are coded words for disability. And if you don't kind of use the disability label at times, that might not give you the ability to use certain disability protections and allow the agency to keep using those manifestations against them. There's also a case we're going to go over later in the slideshow that kind of highlights what is required of courts and CPS when a client disagrees with their disability label. So keep that in mind. Next slide, please. Okay, great. So continuing from where we left off, a tool that folks should consider is plain language, which I kind of previewed in the readily accessible slide. So plain language is simply speaking at a level that more people can understand. We usually recommend trying to attempt to communicate at a fourth to fifth grade level. And it helps not just people with disabilities, but a whole range of people. So people who might be experiencing trauma overload or might be having drug or alcohol withdrawal or limited formal education or learning English as a new language. And it also makes it better for us to also clearly articulate what's going on in the dependency process. A great tool that I like to use is free. It's called Hemingway app, and I can send it to the group online, like over email after the presentation. But it allows you to check what grade level you're speaking at and makes suggestions for you to tailor your communication to a fourth or fifth grade level. So that's a great way to ensure that everything is in a plain language and readily accessible way. You can also use Word to help check your reading level as well. So I'm going to kind of give you examples of what plain language looks like. It unpacks and explains implied language and uses clearer, more common words. So for example, instead of saying something like, this case is seeking injunctive relief only, what you would say is, in some kinds of lawsuits, people are asking for money because something unfair happened to them. But in this case, we're not just asking for money, we're asking for changes in the jail to protect people. We will not ask you for money, but we want to make sure you understand that you won't get any money from this type of case. Brings everyone on the same page, explains any implied knowledge there. We also wanted to go over some disability language guidance. What language changes constantly, and we want to make sure that we're talking to people in respectful ways and accurately capturing disability status. So, for example, some outdated words to avoid are handicap, retarded, or slow. Instead of those words, you can try using someone who has a disability, is disabled, has an intellectual disability. You also want to avoid defining someone by their disability. So sometimes we hear things like this person is wheelchair bound or they're confined to a wheelchair. I hear schizophrenic a lot. What you want to try using instead is this is a person who uses a wheelchair. This is a person who has paraplegia. This is a person who has schizophrenia. Exceptions to that are when a person is blind or deaf, folks there use blind and deaf first. We also want to avoid languages of suffering. So sometimes we hear people in the courtroom saying, like, this person suffers from bipolar disorder or they suffer from major depressive disorder. And intuitively, I can understand why we sometimes use that language. We want to incite care, like a care response from the courts to say, okay, this person might have these certain needs and we need to make sure that we tailor those needs. But in reality, what happens is that when we use suffering language, it kind of forces people to think that we need to medicalize or pathologize a person. So instead, we want to try using neutral terms like this person has major depression, this person has cancer. We want to also avoid euphemisms and imprecise terminology like special needs or differently abled or mental health issues. It's recommended to instead just state the specific disability because, again, we're not embarrassed by disability labels. We also want to avoid references to mental age. We see this so often for parents with intellectual disabilities. So sometimes we see something like, this person has a mind of a 6-year-old or the mental ability of a 12-year-old. I want to remind folks that those are usually coming from IQ tests and capacity can change. So just like we have learned to move across reading levels, people with IDD can also have different capacity and learning abilities too over time. What you want to try instead is stating the specific disability, functional disability, or the need for accommodation. So you can say, Lisa has a learning disability. Lisa has limited reading proficiency. Lisa needs written instructions in plain language with bullet points accompanied with oral explanations. That kind of goes to what the need is and focuses away from trying to demean the person based on their mental age. Next, we're going to talk about how you identify parents with disabilities. Sometimes people have a disability label or diagnosis, or sometimes their disability status has been missed. So you want to screen every client that you have for a disability. And these are some questions you can ask. You can say, did you receive an individualized education plan or IP in school? Did you receive any sort of extra support while you were in school for learning? Do you have SSI or have you ever received SSI or SSDI? Do you have trouble learning new things? What works when you learn things? Do you use pain medication on a regular basis? Are you able to work? If not, why? Do you have any mobility issues? Like, are you able to walk up the stairs or pick up things easily? And ask them about specific allegations that CPS has against them, even if they're not true. So CPS might say this parent has an anger problem. You can show them that allegation and say, CPS is saying this. What do you think about that? Have you ever been told that you have these sorts of issues in the past? And we kind of talked about this. There's pros and cons of disclosing disability, all the ableism reasons, and then what I said before, which is oftentimes disability is the elephant in the courtroom anyway. And when we have a disability status, we can kind of put armor on the person. Like we can use disability protections or case law that requires tailoring of services to disability. So explain to your parent, yes, we get that there's these concerns, and also if you choose to kind of allow us to use disability status to ask for more, it's kind of putting more of a shield around yourself. We also, once we find out what a person's disability related needs are, we can connect them with better services. So you want to connect your parent with appropriate disability services, such as housing services for folks with disabilities. You can look at specific employment opportunities, transportation benefits, personal assistance services, and things like financial or health benefits. We really recommend connecting a parent with the Community for Independent Living in their area. There's organizations like the ARC. States have certain supports, like in California, we have the Regional Center for People with Intellectual Disabilities, and also peer supports. You also want to make sure that you're communicating with providers and support systems in obtaining the proper referrals. Um, what we often come up against with dependency is that they give you boilerplate services, and every parent is expected to go to the same parenting class, the same drug rehabilitation program, and there isn't much else that is designed for people with disabilities. So when you're communicating with providers, you want to identify who's the person who kind of understands what the person's disability needs are and help those providers work with other providers in tailoring those services to better accommodate a person's disability. You also want to obtain sometimes a clinical perspective of your client's symptoms, even if not all the symptoms look the same for every single person, because it can help you navigate your own attorney-client relationship, and help you provide more information to providers on what they can look at to tailor their services for clients. We're going to go over what the fundamental principles of ADA and 504 are briefly as well. So the ADA says a lot of different things, but the two principles that are at the core of it is individualized treatment and full and equal opportunity. So individualized treatment basically just says, how are we going to make sure that each person is treated on a case-by-case basis, based on the facts and the evidence in their life? If you've met, one person who has schizophrenia, it doesn't mean that you understand schizophrenia for every other parent that comes your way and has that diagnosis. And you want to ensure that courts and CPS are also ensuring that they're assessing people on a case-by-case basis. What our regulations require is that disabled parents are not treated on the basis of generalizations or stereotypes. So some examples of prohibited type of treatment is removing a child from a parent with a disability based on stereotypical beliefs of that person's parenting capacity, that disabled parents are unable to safely parent their children. So that would be prohibited. Another one could be denying a person with a disability the opportunity to becoming a foster parent based on stereotypical beliefs about how their disability might affect their ability to provide appropriate care for the child. Individualized treatment kind of goes hand in hand with full and equal opportunity. What full and equal opportunity says is that disabled parents must be provided opportunities to benefit or participate in child welfare programming, services, and activities that are equal to those given to non-disabled parents. That doesn't mean that we're lowering the bar for disabled parents, but what it does mean is that we want to ensure that if this service is being given so that a person can increase their parenting capacity, it has to be one that actually works with their disability related needs. And it can require things like the provision of aids, benefits, and services that are slightly different from those provided to other parents to ensure that they get that equal opportunity to have the same benefit like family reunification. Again, all of this does not mean that you're lowering the standards for disabled parents. It just means that you are asking for services to be adapted and for assessments to be adapted so that we're actually having an accurate capture of what this parent can do and how the parent and child can live together. It may mean ensuring physical or programmatic accessibility by providing auxiliary aids. For example, child welfare services might have to provide an interpreter for a father who's deaf at all of their programming to ensure that he can participate in all aspects of the child welfare interaction. It may mean making reasonable modifications to actual policies or procedures or practices. So, for example, if the child welfare agency makes a referral for a mom with an intellectual disability to a parenting class, she might need a different form of instruction. Maybe group learning isn't best, maybe one-on-one is best. Maybe prompting is required at first. You have to adapt what the program is to meet that person's learning needs. Now, how do you understand disability as part of the case plan? Well, oftentimes, that case plan is designed before we get more information about the person's disability. So we want to ask all those questions that we were asking before so we can come to court and have a bit more of an understanding of what we might want the services to look like. So again, asking all the same things about school history, about if they've had SSI status. And then beyond any diagnosis or those types of questions, you want to ask your parent, is there any other limitations I should be aware about that I can proactively think of accommodations for? For example, I know of a parent who's had traumatic brain injury, and it's really hard for her to follow along during the court process. And in California, not everyone gets access to the transcript. That's only the court that gets it. And she was able to make an accommodation request to see the transcript after her court proceedings so that she could follow along the same way. So that's not fully related to her diagnosis, but she was able to say, I have this limitation. I want to be able to understand more. Can I make this request so I can follow along? You also want to research the diagnosis if there is a diagnosis and use reputable sources. So, if somebody has, for example, chronic PTSD, is requiring them to go to multiple therapy sessions where they're revisiting the trauma the right thing? And is it the right accessible service for the parent? If you research it, you will probably be able to say, no, we need something that's more tailored and once in a while so the person has breathing room. And so you can reference that in your court case. You should also use that type of research to see if the agency is making any assumptions about disability. Is the agency like using a catch-all phrase term for the parent's mental health condition that doesn't accurately describe what's happening for the parent? Oftentimes, what CPS or courts do is that if they are aware that the parent might have some sort of, usually mental health condition, they often go acknowledge that they don't know enough, and then they require the agency to make a referral for some sort of psychiatric or psychological assessment. Um, and oftentimes, what happens is that psychological assessment or evaluation is not contested in court. We assume that that person knows what's best. And so we take whatever conclusions and recommendations they make at face value. But what I want to encourage people here on this Zoom to do is when you're looking at the psychological assessment, make sure you're asking, who is that person making that assessment? Are they someone who is qualified to understand certain disabilities? Have they done research on those disabilities? Are they aware of guidance around how to actually assess a parent with a disability? Did they review all the relevant records, or is the report just mimicking what CPS is saying and includes a few interviews? And also, how much time did they spend with the client in the assessment? This is really important for parenting evaluations, where oftentimes we see the person who's doing the parenting child assessment only viewing a parent's visitation for like an hour or two at a time. And that's not an accurate assessment of what the parent can do. Sometimes parents need natural supports or accommodations in home. Maybe you need longer visitation time to actually see how the parent and child are bonding. And so I would question, if there's only a short visitation time that that person's seeing, if that's an accurate assessment of their parenting capacities. You also want to ask those same questions about assessments that the agency does in their own reporting, and comb through whether or not the assertions that people are making is actually based on an individualized assessment. Are they talking about all of the supports that are around the parent that could be used to mitigate risk, for example? Sometimes I've seen assessments where either the psychologist or the CPS worker speculate about a parent's parenting capacity in this like fictitious world where the parent doesn't have any case managers, doesn't have any family members to support, and says, based on these disabilities, this person's going to cause harm for the kid. And you really want to start questioning those and say, well, the reality is this person has these supports in place. And so how do we assess their parenting capacity with supports in place with the context that they're actually living in? And I should also mention the new 504 regulations explicitly require parenting evaluations to be adaptive. So that means they have to include accommodations and assess a person with their supports in place. You also want to think about, how you can make accommodation requests outside of just the services. So, for example, courts are required to follow Title II of the ADA and 504, even if you're in a state that says the ADA doesn't apply specifically to dependency proceedings. So you can look up a disability accommodation request form in your court and say that there's certain accommodations that your parent requires. Those accommodations could be used for, how a parent requests a transcript or how a parent testifies, or how court processes should be set up so that the parent can fully, engage with the proceeding. Those usually don't get denied. Case plan is us, asking to modify the case plan after the fact. And when you are attacking a case line and saying it's not accommodative of a parent's disability, what you need to be prepared to do is to describe specifically why a certain service or program is not tailored to a parent with a disability. Don't just say, this service well, you could say that the service rejected them because they said that the learning style doesn't fit this parent, or, it's not physically accessible. Like, be specific as to why that service is not fit for that parent. And then be also prepared to recommend a service that could better supplement or address the agency's concerns. An example that I often give is oftentimes parents with intellectual disability are required to go to a parenting class that's over Zoom and in group, when in reality, we know like in-person support is better. So something like parent-child dyadic therapy is a better fit. So even if your jurisdiction doesn't have like a tailored parenting class for folks with IDD, you can look at things like dyadic therapy, which is more common. Um, and you can also always reach out to Dredif or Brandeis to ask if there's any suggestions for certain services if you're not seeing something in your jurisdiction. I also mentioned the case around self-identification earlier on that I'm going to talk about now. This is a California case, and in this case, there was a father who the court was concerned about, mental health conditions, and they were requiring him to do a mental health evaluation. But the father, because of his particular diagnosis, was not able to agree that he had that specific mental health condition. And the psychologist said that his denial is based on the psychological condition and that the lack of insight might be overcome if he gets pharmacological treatment. Now, despite the father's denial of his disability status, he kept going to the clinic that was being required of him to go to at least 3 times to seek the required evaluation for medication. CPS in return kept saying, well, father is not willing to acknowledge that he has this mental health condition, so we met our reasonable efforts requirement. And the court comes back and says, the agency is required to make good efforts to accommodate the father knowing what his disability status is. So we know father's disability status makes it hard for him to acknowledge his condition, but the fact that he kept going to try to get the evaluation shows that he is willing to engage in reunification services and wants to reunify. So I would kind of use that type of logic from this case or similar cases in your jurisdiction to say that the requirement isn't for the person to fully agree with the disability diagnosis that's given to them. What's required is them showing that they're willing to engage in services that are tailored to their disability so that they can get their child back. So focusing on like what actions are the parents actually doing versus whether they're fully accepting whatever diagnosis CPS or the court says that they have. We talked about this a bit in the last training, but we really want to ensure that we make reasonable modification requests early. As the timelines go on, courts and CPS are less and less responsive to making sure that they give you the accommodations you need. And we know that if we set people up for success earlier on, the chances of them in reunifying is better. That being said, if you were not aware of a person's disability status until later on, still make the reasonable modification request. For as long as the parent is in reunification services, make the requests, try to get accommodative services, and challenge whether the agency provided reasonable services and efforts. I'm also going to touch on how you can work with the other side in a dependency case. So what do I mean by working with the other side? It's not just parents' attorneys that are in the dependency court cases. We also have sometimes guardian ad litems, we have the children's attorney, and we have court-appointed special advocates. And the ability to get this other side to understand the aspects of your parent's situation is oftentimes the make or break in whether a person succeeds in their dependency case. A children's attorney and a CASA guardian ad litem, they may all have their own hesitations or concerns because their goal is to focus on what's the best for the child. And it's important early on to start having discussions with them about what does this parent's disability really look like, what services can mitigate that risk, and pushing as to whether they're speculating harm way into the future and not actually looking at the context of that family right now. Sometimes it's beneficial to also get the child's attorney, GAL, and CASA to see the parent's natural supports as part of the team. So I've seen instances where maybe the child's attorney isn't fully on board with the parent, but loves the parents, grandparents who are involved and knows that the parents, grandparents are going to support that parent in reunification. And so appealing to the other side's ability to see the parent as not like alone in parenting and as part of a huge support network is sometimes helpful. We also want to mention, how you can file a complaint with the Department of Justice and HHS. Filing a complaint is quite easy. So you can file a complaint with the DOJ by submitting a report on this website. It's not that complicated to fill out. We can also support you and consult you on how to fill it out. You can fill it out over paper and send it through mail or fax as well. And as Robin mentioned in our last training, the DOJ and HHS are actively involved in investigating issues of discrimination in the child welfare system. So maybe your complaint will be heard by the DOJ and HHS. Similarly, if you want to file with HHS, your complaint must be filed in writing by mail, fax, email, or through the portal. You name the healthcare or social service provider involved, and you describe their acts or omissions and why you believe it violated the civil rights laws or regulations. The key here is that you want to file that complaint within 180 days of knowing of that act or omission, but sometimes there's like a bit of a grace period if you can show good cause. And there's more information available here at this link that you all will receive when you get the slides. And with that, I'm going to pass it to Linda.
Hey, thank you very, very much. Now we'll have a few questions. So one question is, how do you deal with judges who are new to using disability law or use to these arguments about disability law and may not be completely open to them?
That's a great question. Um, I think what's been effective for us at DREDF in California is oftentimes to get judges briefing before they hear a court case. Um, when they're in the courtroom, because these decisions happen so quickly, they're more resistant to hearing about a change and something that requires more time for CPS to find a new service. So oftentimes what I recommend, and you can reach out to us at DREDF or Brandeis because we've helped people draft some of these briefings, is to explain what the parent's disability status is, explain what accommodations do work for the parent, and then cite case law in your jurisdiction that do require judges to look beyond a disability diagnosis. So even if you're in a jurisdiction where the ADA and 504, your state still doesn't recognize it, oftentimes we have found that there's case law that kind of mimics some of that language, even if it's not as strong. And you want to highlight that and say, you're not supposed to just base a decision on a person's disability status or poverty. You're supposed to look at all these other factors, and here are the factors in the parent's case that show that they're not as much of a risk. And also, here are accommodations we've researched and given you, judge, to consider and asking CPS to engage with. And again, like DREDF and Brandeis are here to help you all in doing that. So if you want support with that, you can always reach out.
Thank you. There's a question in the Q&A, and I would encourage people to submit questions to the Q&A. This question asks, any suggestion how we address the cognitive disability when the person is a child subject to manipulation? It's not 100% clear to me exactly what this person has in mind, so I did actually answer back saying, do you mean cognitive disability of the parent? And can you be more specific about the child being subject to manipulation? A little more detail would be helpful here. So if you are the person who submitted that question, please type an answer in the Q&A or the chat, and then Attorney Parthiban will do her best to answer it. Another question is, what do you do when the people involved who are questioning the parent's ability to be a parent are the people, say, in a hospital when a baby is born, and there's a question about whether that child is going to be discharged home, or have child services swoop in and take custody?
Yeah, that's a great question. And like I mentioned in the beginning of the training, oftentimes that is what we see for parents with more stigmatized disabilities like intellectual disability or psychiatric disability. I think this is kind of where we really need some more pre-petition work. So if you're in a jurisdiction where they provide that, that's great. If not, thinking ahead with the parent to say, when you go into the hospital, what are the types of non-formal supports that can be there with you? Or what are some types of services that we can link you up ahead of time with so that we can tell the hospital, this is the parent's plan for safe care upon discharge. Um, Sometimes it's also talking to hospitals and social workers and saying, you guys are also obligated to follow the ADA and 504. And what the ADA and 504 say is that you can't base your decisions on generalizations of a person's disability. For example, I had this one case where, there was a mom who had a plan of safe care. She had an intellectual disability, and the nurse was refusing to discharge the baby with the mom after birth because she kept focusing on the fact that the mom's reading level was at a fourth grade level. And so she kept saying, how can I, there's going to be a certain point where this baby is going to, be smarter than mom. And then what's mom going to do? And it was really important there for us to talk with her and remind her, that's a discriminatory statement. You are, a public hospital, you're obligated by the ADA. You need to be more specific about what the actual risk of harm is. Here's all the safety things that we have in place. And so you speculating to the future when this kid is 9 years old is not a basis for you to deny this parent an ability to go home in safe housing right now. So, hospitals are also supposed to follow the ADA, and there's less contention about that than in dependency. So I would use some of these same arguments when you're chatting with those people.
Okay, so the person who asked that question about um, um, uh, if you had any suggestion about how we address the cognitive disability when the person is a child subject to manipulation, she says that it's the child who has the cognitive disability. Um, Thoughts about
Yeah,
that?
yeah. I think what I'll say is, what we've kind of seen at Dredif is there's a lot of literature about how folks with cognitive disabilities um, sometimes when they're asked questions, they might acquiesce to the question. So they might say, if you ask a certain question a certain way, they're trying to read your facial expressions to see what answer you want, and they'll answer in the affirmative based on that. And so something that we have done is we've asked people to say, when you're asking questions of a person with an intellectual disability, how do you give them multiple choices and not just let it be yes or no answers all the time? So that could be a way to kind of support you in seeing whether this person is being subject to manipulation or not. Um, and if you want to email me directly, I can kind of share the court accommodation that we asked for a parent on that regard, so you can kind of copy that language there.
Thank you. So, um, another question is, do you have a brief bank that has samples of disability and dependency issues?
Yes. So at Dredif, we do have a brief bank that we created. It's very much focused on California. So, folks in other states, you can look at that and try to see if there's similar case law in the state. What I would say before that big asterisk is if you are going to use one of our brief banks or the logic behind them, I would really recommend consulting with Dredif to see how we put out the ADA and 504 analysis, because we want to ensure that we don't create bad case law in the future. So if you want to like reach out and we can share the brief bank, tell us briefly what's going on with your parent. We can make suggestions for, do you want to more heavily focus on the state case law that says similar things, or do we want to incorporate more of the ADA and 504 advocacy in there too? So happy to share the brief bank. Just make sure you check in with us so we can make sure there's no risk in the appellate court in your state.
Great, thank you. And then another question is, when your client doesn't have a supportive community, how do you balance between asking for accommodations and services compared between putting the client at risk of CPS, saying the client can't parent without CPS's help long term? For example, this person has a client with physical disabilities who can't keep the home clean but has been struggling to get a home health aide?
Mm, yeah, that is such a good question. And I think the reality is, I think we mentioned the Sarah Gordon case in our last training. And the Sarah Gordon case is such a wonderful example of how we can push on natural supports and formal supports to help someone reunify, even if it takes too long. And the reality is in the Sarah Gordon case, she is white, and folks who are white have different experiences in the child welfare system than folks of color, and also had family support. When in reality, a lot of people with disabilities are isolated and might not have that. Um, what I would focus on there is what the child welfare agency's duty is. So if that parent is saying, I applied for an IHSS worker or I applied for a personal care aide and there's a long wait list or I'm being denied, then as the attorney, what you can do is say, look, my client has been trying to find the accommodation for themselves to help the home be safe. But really, it's your duty, CPS, to give the client the service that they need to reunify. So are you sitting with my client? Are you also figuring out like whether an IHSS referral should be made? Are you tapping into your agency's resources to give them that personal care? And it's a harder, I'm not saying that that's going to solve the issue and everything's fine because CPS is going to push back. But the reality is that when CPS says they're being involved, their whole shtick is that we're going to help give you the services you need to make your home safer. So it shouldn't just be on your client to be trying to figure out what those accommodations are. Alongside that, I want to say it's really important for attorneys to also be aware of like what type of disability services are available. So maybe in your jurisdiction, you have like a legal aid org that does know how to do SSI, that does know how to appeal IHSS decisions. You can always reach out to your protection and advocacy center in your state. So, in California, it's Disability Rights California. It might be Disability Rights Minnesota, and ask them, what are ways that we can help our client if they've been denied these certain resources, and can I point them to somebody that can help them? So it's a two-part thing. Push CPS. You also reach out to your PNA or your local orgs.
Thank you. And then I think this may be our last question. Can you point to any case law or studies about the importance of the bond between parents and children with the same disabilities?
That is such a wonderful question. So what I can point folks to is, and I believe Robin mentioned this in our last training, is the National Council of Disability has Rocking the Cradle. And Rocking the Cradle has a bunch of disability experts who talk about this issue of parents with disabilities losing custody, and they are the ones who point out these studies that say like disability is not predictive of abuse. So maybe that might be a place to find that specific research that you're naming. I also want to mention though the problem is that the research that we have is pretty scarce because researchers decide what they want to research. So unless you have someone, like Robin at Brandeis who's saying, let's actually look at the bond between disabled parents or not, that article might not exist. And also National Council for Disabilities will show you people that might be doing that research. Um, I also think it's fine to kind of just like explain that. Sometimes I've said in court, mom has autism and the kid has an intellectual disability, and mom understands what it feels like to move through the regional center and is saying she wants to help her kid move through the regional center. So this parent actually knows what's best more than a parent who doesn't have any idea what the regional center looks like. And maybe just breaking it down that way can help a court understand without a research article. And maybe there's a research article. If there is, please share it with me.
Terrific. Oh, there is a question here. Um, I think Nicole Lomerson has something she wants to add. Nicole?
Nope, I just put the question in chat so you would see it. What
Okay.
are some questions you can ask parent capacity evaluators to best evaluate if they have the experience you were mentioning necessary?
Yeah, that is a beautiful question. Um, so something I ask quite often is, what is your practice when you are evaluating a parent with a disability? Do you change your evaluation process when that parent has a physical disability? Do you ever observe the parent in their home with the child? Do you observe the parent with their aides, whether it's like a family member support or their IHSS worker or their personal care attendant? how do you ensure that accommodations are there in the evaluation process? Um, and oftentimes when I ask those questions, people say, oh, I don't do anything that different. And then the follow-up question there isn't to say that this person's not the person to evaluate, because we know, the perfect parenting evaluators are unicorns and they're far and small in between. But you can say, like, if I pointed you to a resource that helps you figure out how to make sure that your assessments are adaptive, are you open to that? And if the person says yes, great. You can also say, can I talk with you about what the assessment process looks before you publish your report with the agency? If they say yes, that's also a great sign. If not, then you might want to find a different evaluator who is more willing to work with you in figuring out how to adapt their assessment.
Great. Thank you so much. Those are really all really terrific questions, and I really appreciate you taking the time to answer them. So if we move on to the next slide.
Let me try sharing screen.
All right, so resources. So yes, there are quite a few resources. The National Research Center for Parents with Disabilities that we mentioned last time, as well as the Disabled Parenting Project. The Disabled Parenting Project is sort of a parent-to-parent project, and there's just a lot of wisdom gained from years and years of parenting that you can find there. Rocking the Cradle, as Kavya mentioned, and also the Child Welfare Information Gateway. The Association of Successful Parenting, as we mentioned last time, um, includes a lot of trainings for people who work with parents with particularly intellectual disabilities. And lastly, the Bazelon Center for Mental Health Law, um, which, as the title says, focuses primarily on mental health issues. I'm also putting in the chat once again the link for the Job Accommodation Network. As I mentioned it last week, it does have accommodations, although they are intended for work, they are also incredibly useful in a variety of settings in schools and with parenting. So whenever I'm trying to help somebody figure out an accommodation, that's the first place I go. So that is that link is in the chat. All right, so you can see we have a Twitter account, we have a Facebook account, and you can reach us at lori.brandeis.edu. Next slide, please. And of course, just as last week, this effort was a joint project of the National Research Center for Parents with Disabilities and the Disability Rights Education and Defense Fund. And we want to thank Kavya from DREDF for leading us through this really terrific presentation.
Linda,
Next slide,
can I
please.
add one more thing very
Sure.
quickly?
Sure.
The National Research Center for Parents with Disabilities, we are a federally funded grant. And as such, everything in this presentation were the opinions of our speakers and not necessarily of our funder.
Okay, thank you. All right, so next slide, please. So this was funded, speaking of funders, this was funded by NIDLR, the National Institute on Disability, Independent Living, and Rehabilitation Research. And next slide, please. And for those of you who received survey number 1, please complete survey number 2. We really do want to understand the impact of our training, and that will help us with future trainings to focus our efforts. If for some reason you should receive you should receive the survey at 3:03 p.m. If you do not receive the survey at 3:03 p.m., please email me at linda.long@umassmed.edu. Or you can also, just email me at linda.long@umassmed.edu. And we will make sure you get your survey. Thank you so much. We really appreciate your attention and your patience today. And again, thank you to Attorney Parthiban for sharing so much helpful information. Thank you.